by way of background and so forth.
I was a...
Let me just say something first. This is Jerry Barrett talking. Today's date is April 24th, 1986. I'm interviewing Richard Magurno in his office at Eastern Airlines headquarters in Miami. Mr. Magurno is Senior Vice President, Legal Affairs, and Secretary of Eastern. Mr. Magurno, if you would, could you talk a little bit about what you did before you came to Eastern by way of work experience and education?
I graduated from Georgetown University in Washington in 1964 from the Foreign Service School. I then received a master's degree from the University of Wisconsin, and a master's in American history in 1965, and went to the Fordham Law School, where I graduated in 1968. I then spent some time in the Peace Corps, and then came and joined Eastern on May 1st of 1970. It's been my one and only place of employment.
Okay. One of the things of key interest in this whole inquiry that we're making is about the events that took place that Sunday in February of 1986, when ultimately the corporation was sold. Can you talk a little bit about that, the events leading up to it, and what you recall about that?
Would you stop for a second? To make sense of what occurred on February 24th, that evening, you really have to go a fair amount back in time with the various strategies that the company was pursuing, looking to the need to obtain or achieve new labor agreements with at a reduced level. In the summer of 1985, I'd been asked to, late summer, early fall is a better time frame, I'd been asked to look at the possibility, once again, of Eastern filing a bankruptcy petition and re-examine the current state of the law in that area against the possibility that we'd be unable to achieve labor agreements. Same strategy we had followed the prior year. By late September, when it became apparent that the company's financial problems were on an escalating downturn, I was given additional instructions to ensure that we were prepared to file a bankruptcy petition. We started that with some measure of significant activity in mid to late October. A piece that was discussed in the fall and winter was the possibility or the desirability of having a strategy that looked to an alternative to bankruptcy, a strategy that in my mind was designed to create the appearances of the company being interested in a merger or a sale. My understanding was the company's only interest was in a merger in which Eastern would be the surviving entity. In early to mid-December, Colonel was contacted by Mr. Lorenzo to discuss the sale of Eastern's computer reservation system, or at least participation by Lorenzo and Texas Air in the computer reservation system. Conversation between Borman and Lorenzo takes place in New York at Rockefeller Center, and during the course of that conversation, Borman reported that Lorenzo made some reference to the possibility of his being interested in acquiring Eastern. Colonel came back and reported that, and did so in an enthusiastic way, initially with a direction that we immediately call the board into session so that we can posture the company as actively pursuing negotiations with Texas Air. In fact, his intent was simply to create, as we all understood, was simply to create the appearances of a desire to sell the airline. We persuaded him that his course was somewhat dangerous, that if he put the airline into play, particularly if we started inviting acquisition offers or buyouts from Lorenzo, we would lose control of the situation, and that we needed more than anything else the flexibility to follow various courses of action. After some extended discussions with counsel and with Merrill Lynch, Borman was persuaded that he would, in a later meeting with Lorenzo, all he would do was explore the possibility of Texas Air's interest. What we understand, that was indeed what took place at a meeting that was held in Fort Lauderdale later in May. The Colonel was also persuaded that it was not a good idea that we call the board into session to review with the board this particular activity, since once again it would place upon the board, who was also being asked to look at the possibility of bankruptcy, it would place upon the board the obligation to more actively pursue a Texas Air proposal. Texas Air stayed on the sidelines for a while as we continued through December and January with some very difficult negotiations with labor. In early February, late January, early February, we had discussions as to the desirability of bringing Texas Air back into the picture as a vehicle to induce the unions to accept labor concessions. There never was any intention to, in fact, at least at that point in time, there never was any intention to, in fact, sell the airline. In middle of February, we had some discussions with our investment bankers as to how we would posture an arrangement with Texas Air. We discussed that with the executive committee on, for instance, February 13th. We reviewed the desirability of approaching Texas Air. Let me stop this. By early February, the company's announced position was that we were either going to have labor contracts, file a bankruptcy petition, or sell the airline. And that's basically the strategy that the executive committee, as well as management, undertook to follow. We discussed, during the week of February 10th, we discussed with our investment bankers how we go about making an approach to Lorenzo. We were trying to structure a situation where Texas Air, where we could announce to the unions that we're discussing this matter with Texas Air, and that at the same time we had enough time to negotiate labor agreements between the time of the announcement of the Texas Air discussions and what we presumed would have been a deadline date set by Texas Air. Lorenzo had told Borman as early as December that he would not be used as a shill for Eastern to solve its labor problems, that what he wanted was an agreement from Eastern. If Eastern wanted to pursue possible merger with Texas Air, he wanted an assurance that Borman would take to our executive committee of the board of directors a recommendation from management on a deal that had been negotiated by management and Texas Air. Absent that, he was insisting he would not proceed with any kind of merger discussions. February 17th, our investment bankers called Lorenzo and alerted him to the fact that Eastern will probably by the end of that week want to talk with him about a possible combination. Lorenzo's response was something along the lines that he might be interested, but he wanted to do a very quick deal. He didn't want to simply drag something out for the purpose of helping Eastern labor relations. During the course of that week, the company received some valuation studies from Merrill Lynch so that we could get an idea of a price for the purpose of negotiations. And finally, on later that week, there apparently was a second conversation between Merrill Lynch and Lorenzo, and there was a discussion that any deal that would be put together would have to be put together very quickly. We went through various formulations of what the likelihood of a proposal from Lorenzo might be. We also anticipated that he would insist on no solicitation provision, which meant we'd be locked into our proposal with him, as well as some large breakup fees in the event that the merger agreement fell apart. During that same period of time, we're actively involved in planning a bankruptcy. I think by middle February, we're pretty much prepared to file a Chapter 11 at any time as it became necessary to do so. Throughout this point, I think the company's feeling was both the bankruptcy threat and the sale threat would, in the end, be enough to motivate labor to accept new labor contracts. During the week of the 17th, we had a variety of discussions with different representatives of the labor unions to test the waters on the likelihood of our being able to reach an agreement. By the middle part of that week, we're becoming somewhat discouraged about the possibility of moving the machinists in particular. There had always been a feeling that ALPA would in the end come to an agreement, and the TWU would simply drag in along after ALPA. The key to the whole operation was what the machinists would do. We had an executive committee meeting on February 20th in the evening, and at that time we again reviewed the strategy. We heard a report from Merrill Lynch on the valuation of the assets, and at that time the executive committee agreed that the following day a proposal would be made to, an invitation would be made to Texas Air to propose a merger agreement with Eastern. So again, the intent at that point, or the assumption at that point, was that there'd be enough time after the initial discussions with Texas Air on February 21st, there'd be enough time for us to use those discussions to our best advantage and to also reach an agreement before our deadline date of February 28th. On the afternoon of February 21st, Merrill Lynch contacted Texas Air and solicited an offer, and we then began a series of negotiations with Texas Air. One of the conditions that Lorenzo put on the deal is it had to be closed by Sunday night. He made an initial offer to us that we felt was too low, was $9 a share, with a number of conditions that we found unacceptable. What followed on that was a long weekend of negotiations continuing Friday night until very late, continuing Saturday into the early Sunday morning in Atlanta. How detailed? Principal considerations were the price that the airline was being, at which the airline was being sold, and the conditions under which Texas Air could walk away from the deal. Up through Sunday evening, the conditions that would allow Texas Air to walk away were the subject of most of the discussions. On Saturday, the 22nd, in the afternoon, there was a meeting with labor to tell them that we had the Texas Air offer, it had a 48-hour deadline, and that the board was going to act on it on February 23rd, And on that evening, the airlines were either going to be sold or we'd have labor agreements. And the board had no choice but to take one action or the other. This was consistent with what the board's outside counsel had previously told labor was essential, or was the action that the board would take. On the morning of the 22nd, there was a meeting in which we determined that we had to have an offer for the executive committee to consider, that the executive committee would meet Sunday morning, and by that time we needed a proposal for them to accept. We had a 5 o'clock meeting, 5 o'clock in the afternoon telephone meeting of the executive committee that reviewed the proposal that was in place at that time. By then it became apparent to some of us that Texas Air was determined to go ahead with a bid, and that it was going to be a legitimate bid, and it was going to become very difficult for us to walk away from it. It also became apparent to us, to some of us, that at that time it was more than likely that the airline was probably going to be sold. That feeling stemmed in large part from the sense that we were not going to get labor to participate, most particularly the machinists. Late in the afternoon on Saturday, there were some telephone calls between Borman and Lorenzo that touch on certain aspects of the deal, most particularly the need to remove the contingency that would permit Texas Air to walk away from the merger in the event Eastern had a strike or filed a bankruptcy petition. There was discussion about the timing of a possible merger. Most likely it would be 4 to 5 months between application and approval. Late that day, we became aware as well that the unions had taken the discussions that we'd had earlier in the day with them to the media, and that the media was now calling the company concerning the ongoing discussions with Texas Air. As that day progressed, we came to the sense was created that the board had to act on Sunday, because if they failed to do so, there'd be no extension of time on the by Texas Air on the sale. The executive committee met by phone at 8 o'clock on the morning of the 23rd to get an update on where they were in the contract, what the out clauses were in the contract, and we agreed that there would be another informal meeting of the executive committee in the early afternoon. That Sunday morning, there's a call from Borman to Lorenzo that talks about the strategy before the executive committee, that Lorenzo tells us he'll back out if he smells a rat in this, and that he has no intention of going forward if he thinks we're going to allow him to be used as a shill. 2 o'clock, the board meets. we present to the board a copy of the then current draft of the merger agreement. It's described in some minor detail. Charlie Bryan, during the course of that meeting, indicates that he did not attend the board meeting for the purpose of negotiating on his labor contract, that 4 or 5 months earlier he had given written reports to the board and management with respect to the problems the company had. He had demonstrated the machinist's ability to save money for the corporation, that he had not seen any response by the corporation, and that he felt management was not properly running the operation. He indicated that he would not see any modifications to his agreement until he saw an interest on the part of management to solve the company's problems, and he was not at all receptive to opening the contract. The meeting ended to be resumed at 7 that evening. The outside directors were then taken over to a suite at the Hilton, and there was a informal but very lengthy meeting of the outside members of the board with counsel. During that meeting, the entire proposal was discussed in all of its ramifications, as well as possible strategies in dealing with labor. The board actually resumed its session at 7:45 that evening. We went through, during the course of that night, we went through a full discussion of what the agreement was. The board had a very strong concern with its potential liability. Sometime during the course of the night, Lorenzo came up with a proposal whereby he would indemnify the board with a separate indemnity for about $30 million. He also dropped out all of his potential out clauses, so that basically we had an agreement in which Texas Air is locked in and can't walk away from the deal on almost any basis. Let me stop for a second.
This is Jerry Barrett speaking. I'm continuing the interview with Richard Magurno at Eastern Airline Headquarters in Miami. Today's date is April 25th, 1986.
I think it's important that we, in order to better understand what occurs on February 23rd, that we go back a little bit again in time. Keep in mind that in middle January, the unions announced an attempt to acquire control of the company. In response to that, the company quickly undertook to adopt the so-called poison pill, which is a mechanism to force any entity that seeks to acquire the company to deal directly with the board of directors. That's accomplished by having various thresholds of stock interest, so that in the plan that we devised, if any entity acquired more than a 25% interest in the company, the so-called poison pill was detached from the stock, and at such point as that same entity acquired more than 35% of the common stock of the company, the poison pill exploded, which means that the stock base is increased significantly. The effect of that is to say, if you had 35% control of the company, poison pill explodes, your interest is effectively reduced to about 18%. The intent is to make it more difficult for any acquiring party to acquire the company simply by stock purchases. And in the union's case, we had a concern because the combined union interest is about 11 or 12% of the stock of the company, which gave them a good base from which to begin. The analysis of that, it was very curious, because we felt that it was unlikely that the unions by themselves could mount an effective takeover campaign, and that they therefore had to have some other entity that came in to assist them. The poison pill was adopted in late January. At the board meeting where the poison pill was adopted, there was some discussion or dissent from Charlie Bryan, the president of the Machinists Union, supported by Tom Boggs and Arthur Taylor, who are the representatives of the pilots union on the board. The Taylor-Boggs argument was that the poison pill plan that the company proposed to adopt didn't include an exception for employee stock trusts or employee ownership plans. We have been very careful to ensure that that exception didn't exist in our plan because we're obviously because of the union stock holdings in the company. Bryan argued that this was unfair to the employees, that the employees had a role in this company and we were in some way disenfranchising them. Since the basic intent behind the plan was to ensure that there'd be no employee or union really takeover, because again the concern was more with a union attempt to take over the company, although again we didn't believe it could succeed unless they had some other entity that would come in. There were rumors of other possible forces at play, that Tom Boggs was supposedly putting together a group that included Lee Iacocca and other named persons to enter into some proxy battle with the company for control of the company. The poison pill was adopted in late January. Shortly thereafter, Bryan had been involved in encouraging his membership to buy stock in the company. He had apparently been attempting to expand the IAM stockholder base so that his role could be increased. We decided quite literally at the last minute before an early February board meeting, right off, I don't remember the date of the meeting, I believe it was take that back, it may well have been the board meeting on January 30th or 31st, I'm not sure the exact date. We changed the record date for the meeting. We had originally established a record date for stockholders of record and people as of record on that day could vote in any annual meeting. We changed the record date, moved it back to February the 12th, which effectively cut down the solicitation period or the purchase period for the union people to a week and a half, which effectively meant they weren't going to be able to acquire enough stock to have any effect. Bryan vigorously objected to that because obviously he was looking at a strategy that would allow him to allow his membership to increase their holding and therefore increase any takeover attempt that he might want to be a party to. During the month of February, there are continuing discussions with ALPA and the TWU over new contract terms. In January, with respect to ALPA, there had been a weekend meeting in Washington during the weekend of January the 24th, 25th, and 26th. At that time, the parties thought that we would be able to reach an agreement with ALPA. There had been some assurances given to us from ALPA International that we would have, with some modifications to our basic agreement, that there would be the possibility of reaching, or with some modifications to Eastern's original proposal, there would be some possibility of reaching an agreement with ALPA. Many of us felt that was not very likely, but we worked through the weekend, and at the end of the weekend, ALPA walked out. That then set the stage for an ALPA national telethon or system-wide briefing by various ALPA people along about the second week of February. That we viewed as very dangerous because it set up a time frame set up enthusiasm for a strike at a time frame when there wasn't enough time after the event and before our deadline date to reach some type of accommodation with ALPA that would save face for everyone. That, in my mind, also had a role in stimulating the need to find yet another lever to induce ALPA to look to a settlement, and that in turn provides a foundation for the Texas Air activity that takes place later in the month. Yesterday we talked about the slow evolution of the Texas Air process. Throughout this January and early February period, there are references and discussions that we have with the Colonel over the possible strategy of bringing Texas Air in, and the key question of timing as to when you bring Texas Air in. Bringing Texas Air in too early, in our mind, put the company in play, and once we put the company in play, we lost our flexibility, and we risked the strong possibility that the company, in fact, would be sold. Since we discussed some of that other background yesterday, let me just quickly jump to February 20th, when we had an executive committee meeting on the evening of February 20th. The intent of that meeting was to review the valuation studies that Merrill Lynch had prepared for the company. These were studies of the value of various of the company's assets and the value of the company as an ongoing entity. The intent of those studies was twofold. One, to provide a foundation for any discussions with Texas Air as to the value of the company. That evening we were provided with a range of stock prices, or a range of prices for the stock that would be reasonable if the company were to be sold, as well as valuation of particular assets. The intent of the individual asset valuation was to raise the potential specter of the company being split up and sold in pieces, or certain pieces put into subsidiaries that could ultimately be sold to other parties. That evening, the discussion with the executive committee following the valuation reports focused very strongly on where we go with the Texas Air strategy, and it was clearly determined that that following day the board would be asked, and we assumed the board would approve an approach to what was then an unnamed, for board purposes, an unnamed entity that had expressed an interest in merging with the company. I think that evening there was, if I were to gauge the feelings of the members of the executive committee, a sense that there was a possibility of the parties following this strategy of the parties reaching a labor agreement before the end of the month. I don't think at that time any of the members of the executive committee expected that the Texas Air strategy would in fact lead to a sale of the airline. We discussed that evening the board meeting the following day and the likelihood that we'd have a board meeting the following Monday or Tuesday. There were strategy considerations that came into play with determining whether you'd have a Monday or a Tuesday meeting. The logic being that by Thursday we needed, Thursday being the end of the month, we needed to have a resolution of the labor situation or filing a bankruptcy petition. There was discussion Thursday evening that with the executive committee that there was a logic to filing a bankruptcy petition as early as Wednesday of the following week, since that would allow the company's interline agreements with United, Delta, and American, agreements that were considered critical in preserving the agreements in order to have an ongoing company filing a bankruptcy petition. It's considered that, and those agreements in turn expire at the end of each calendar month. We had long, in considering the bankruptcy, looked at the date when we file a petition in bankruptcy. The thought was either file it before the end of the month, or or in the early days of the following month. We'd either file a petition on Wednesday, the last Wednesday in February, or we'd file a petition sometime after the first of the month, after the company had already gone into default under the indenture. There's a logic to both strategies. But again, there was thought given that Thursday night with the executive committee as to whether or not the company should in fact consider a filing for that following Wednesday for the purpose of preserving the interline agreement. Also gave us the opportunity to do a bankruptcy filing prior to the date of an ALPA strike, which also was a consideration. The next day at the board meeting, the principal focus of the meeting was presentations. There were two areas. We did presentations on bankruptcy, presentations on the sale, and the Merrill Lynch valuation study. I think the union members of the board, when we did the presentation on the possible sale, my sense was they viewed what we were doing as a strategy and not as something that likely would take place. Bankruptcy, I think, was viewed by the union people as a far more logical or far more likely possibility. We structured that meeting in such a way that the union members would come to a full understanding of the reality of the bankruptcy. We specifically invited all of the bankruptcy lawyers. We had a firm from San Francisco. We had two members of that firm. We had two people from the Gambrell firm who had been working on bankruptcy matters, and we had three people from the Greenberg firm here in Miami who would act as local counsel. The Greenberg firm participants included the former governor of Florida, Reuben Askew, who we specifically wanted in the boardroom to impress upon the union leaders the preparation and the imminence of the possibility of a bankruptcy filing. The board meeting was in the morning. Following the board meeting, Jeff Berenson from Merrill Lynch made a call to Texas Air and to Mr. Lorenzo, and thereafter we began discussions on the Texas Air proposal to us. Some of those discussions we discussed, so the details of those discussions we discussed yesterday. There was disagreement among some of us over the price that Merrill Lynch was proposing. We felt it was too low. We were told that the realistic price was, in fact, and the price that Texas Air was most likely to respond to was in the $10 range. In a later conversation that I've had, a very recent conversation that I had with Mr. Lorenzo, he did indicate that from Texas Air's point of view, the $10 price was pretty much the outside limit as to what they're willing to go, given Eastern's financial condition and its problems with labor. We worked very late into the night on Friday night with Wayne Yeoman, Ralph Andreessen, Howard Turner, and myself, along with Jeff Berenson and Ray Manella from Merrill Lynch. We had a series of telephone conference calls from Wayne Yeoman's office to Lorenzo and to the various finance people at Texas Air. By about midnight on Friday night, we began to think that the contours of an agreement were emerging. We agreed that the parties would meet again in Atlanta on Saturday in the Gambrell offices. Middle part of early Saturday morning, Howard Turner and I met with Wayne Yeoman and Ralph Andreessen here in Miami to discuss the conversations that had taken place the night before. And Wayne, Ralph, and Howard flew up to Atlanta to continue the discussions with the Texas Air people, who also flew to Atlanta. From Texas Air, there was Charlie Goolsby, who's Texas Air's general counsel, Rob Snedeker, who's their chief financial officer, and Bob Ferguson, who is one of their financial people. those two sides, or those people from each side, negotiated the agreement. The fundamentals of the agreement came from the Texas Air TWA merger proposal that had been discussed in the summer and fall of 1985. On Saturday, at 1 o'clock, the company had called in the union leaders to a meeting at the auditorium in Building 16 to disclose that the Texas Air proposal was now in place and that we had a 48-hour deadline on responding to the proposal, and that the board would meet on Sunday, and at that time would consider the Texas Air proposal. Among the participants from the company side at this meeting was the board's outside counsel. Earlier in the year, the board, out of concern for its liability, had hired to represent the outside or the non-Eastern Airlines members of the board of directors. They'd hired their own attorney. The firm that they had retained was Davis, Polk, and Wardwell from New York, and specifically Dick Spazzeri and Lou Caden. Spazzeri made a presentation on Sunday in which he said, as he had previously said to the union leaders, separately, but this time in a group, that on Sunday night the board was going to do one of three things. They were either going to sell the airline, presuming we had a valid offer from Texas Air, authorize the filing of a bankruptcy petition if the Texas Air deal fell apart, or find it did not have to take either one of those courses if we had effective labor agreements. The strategy was to, in effect, force labor to come to agreements by Sunday evening. There weren't very many comments from the union leaders at that meeting. I have a recollection that Larry Schulte, who's the head of the pilot group, had some comment to the effect that it's now or never that we've got to do something. The unions had retained the Skadden Arps firm. There's a fellow from Skadden Arps who asked if we had details of the Texas Air proposal. We said we did not. We had expected that meeting would produce a somewhat more vigorous reaction on the part of the unions, at least have the unions respond in some way that made it clear they understood what was about to transpire. As that day and the next unfolded, I came to the conclusion that the unions didn't take too seriously the possibility of a Texas Air sale, and that they viewed it as only strategy on the company's part, and little more than that. Let's just stop for a second. Going back over my notes, I see there are some other meetings. At 9:10 on Saturday morning, we had a meeting in the Colonel's office. It was attended by Borman, Ussery, Yeoman, Turner, Jack Johnson, Joe Leonard, Rolf Andresen, Lou Caden, Dick Spazzeri, and myself. That time we started laying out the strategy for the executive committee and for the board the following day. We did go end for the union meeting at 1 o'clock. We determined that Spazzeri would set the framework for the meeting, would go through this discussion that we required, that he was going to advise the board to either act on a Chapter 11 petition, act on a reasonable offer from a potential buyer, or get labor agreements that were acceptable. About a half an hour later, substantially that same group took a call from Jeff Berenson, the Merrill Lynch person, with some further details on the merger agreement. At that time, we started talking about the possibility of a Texas Air option to acquire 10 million shares, a so-called lockup option that would bring them up to 51%. The lockup is a device that had been considered in various Delaware cases. We also talked about the cash securities component of any offer from Texas Air. Berenson told us at that time that Lorenzo wanted to talk to Borman. We discussed what the nature of the Borman-Lorenzo conversation should be. We decided that we'd tell him that the executive committee of the board would meet at 5 o'clock on Saturday, that the executive committee had authorized the colonel to get the best deal he could find and then take that back to the executive committee, and that he should tell Lorenzo that he believes the executive committee will authorize the taking of the offer to the board, but the executive committee will not make a positive or negative recommendation. We're told by Berenson from Merrill Lynch that Lorenzo wanted the executive committee to endorse the offer. At about 10:20 that morning, Borman called Lorenzo. In the office during the call was Howard Turner, Dick Spizzeri, Wayne Yeoman, Rolf Andreessen, Luke Hayden, and myself. Borman described to Lorenzo what took place on Thursday evening with the executive committee, and on Friday that management had been instructed to seek an offer if one was available, that Lorenzo had established a deadline of Sunday evening, and that we had decided we'd have an executive committee meeting Saturday afternoon and a board meeting on Sunday. That Borman made the comment during the course of the conversation, "I'm an amateur in your game, that you know all about takeovers and I don't." Lorenzo said to Borman, "I've told you before, I will not be a shill for you." Borman's response was, "I first met with you in New York 2 or 3 months ago, and during that time I haven't used you in that way at all." Borman mentioned that he has labor members on the board, and that this makes dealing with the board somewhat more difficult, and that inevitably, because there are labor members of the board, without regard to what the company might do to ensure the confidentiality of the dealings, Lorenzo had to assume that something might be said and that it might be viewed in a particular way. At 1:30 on Saturday, I was incorrect before as to the timing of the labor meeting, it was at 1:30, that we had the meeting with the various representatives of the labor unions. Borman began the meeting by saying that up through the fall of '85, the companies seemed to be on the right course, but that in October of 1985, the market situation had changed significantly, and that the company fell into some serious difficulties. That as early as the fall, he had started a search for merger partners. He went through the names of the various parties he had talked with. That right now, the fourth quarter looked like it was going to be a disaster. That Eastern had a good airline, a good product, but it had a cost structure that simply couldn't survive. Management has no desire to argue with the unions. We have no desire for confrontations with the unions. That the company's cash position is what was driving events. Yesterday, on Friday, the board had authorized management to look for a merger partner. Merrill Lynch had called the one entity that had expressed any interest, and that we were in the process of beginning negotiations on a definitive agreement, that a deadline had been set, and that by midnight Sunday, the company had to take some action. Dick Spizzeri, the attorney for the outside or non-Eastern members of the board, then spoke. He had said that his firm had been called in not by Frank Borman, but by the outside members of the board in November, and that they were advising the board, outside members of the board, in a particular way, that the interest was not the interest of management in this instance, but rather the interest of the board of directors. That he had attended a series of meetings of the executive committee and the board during the course of the last few months, that the board has a fiduciary duty to the stockholders, and that while in the past the business judgment rule had protected the board members from potential liability, that rule has been significantly eroded, and the directors were concerned about their personal liability in this instance. The executive committee and the board had adopted a particular strategy. There were either to be labor contracts, the airline was to be sold, or the airline was to go into bankruptcy. If it was going to take that latter course, it had to have enough cash to survive the filing of a bankruptcy petition. His feeling, and the way he was advising the board, was that the stockholders were best off if there were best served if there were labor contracts in place, or if the airline was sold. That the third alternative, the bankruptcy alternative, would be followed only if the first two couldn't be accomplished. He said that on Friday, management had been told to seek an offer of merger. In anticipation of that offer, there had been original plans to have a board meeting on Tuesday. Events overtook that, and the offer came yesterday, and it had a time constraint on it. Spizzirri said he had reviewed the offer, and he found it to be a serious and substantial one, and that Merrill Lynch would probably render an opinion that the offer is fair. The offer is unconditional, that we were trying to negotiate out any outs for the acquiring entity in the event Eastern filed a bankruptcy petition, went on strike, or had any antitrust problems, and that it was being structured in such a way that it would permit the buyer to quickly acquire a 51% interest in the company. Spizzirri said that he would advise the board that unless by tomorrow evening there were contracts in place that contained significant wage concessions, that he'd advise that the offer must be accepted. If the offer is not accepted and goes away, then the company would in all likelihood go into bankruptcy. There was then some questions from the union persons attending the meeting as to whether or not there had been other offers. The response was yes, we'd attempted to deal with other parties, but none had been, we'd not been able to reach any acceptable undertakings. There was a question as to whether or not there was going to be any further search for potential buyers. The Colonel responded that there's no opportunity to do that. The cash position of the company, which was fast deteriorating, removed the possibility of there being any opportunity to seek other buyers. The problem was right now, and it had to be resolved right now. And that in the absence of labor contracts of the sort the company had been proposing, namely contracts that would reduce the cost and significantly change work rules, then the board has to consider the sale of the airline.
Let me turn the tape over.
Sure. And again, is that too detailed?
No, that's fine. Okay, we're back on.
On Saturday afternoon at about 5 o'clock, we had a telephone meeting of the executive committee. Prior to the meeting and during the course of the afternoon, we'd had regular inputs from the discussions in Atlanta as to the status of the evolving contract, and there were still several open issues. The 5 o'clock meeting, we reviewed with the executive committee the fact that we had an offer, that the offer expired Sunday night. We reviewed the meeting earlier in the afternoon with the unions and mentioned that we had begun negotiations with ALPA and the TWU by late afternoon, but that there were still no discussions with the IAM. We then went through the Details of the agreement: Jeff Berenson from Merrill Lynch described the plan as it then stood. The plan then was a $6.25 cash offer and $3.75 paper offer, pretty much the payment position that we ultimately ended up with. We also had given them, we discussed that afternoon, the fact that there were some options that would permit them to acquire 18% of the authorized but unissued shares at $7.50 a share. That was an option they could exercise at any time. That found its way into the final agreement. There was also a provision at this point that would permit them to acquire in the open market up to 20 million shares, so that the end product of their various rights would be to give them 51% of the stock of the company. And once again, that was pretty much the final format as well. There was some discussion on the breakup fee. I believe by Saturday afternoon there was still a concern about the size of the breakup fee. That was the $20 million payment that we ultimately made. The most serious area of discussion was on the so-called material adverse condition. Texas Air was insisting on a provision that would permit them to walk away from the agreement in the event there was a material adverse change in the company's condition. At that time, it included strikes, a filing of a Chapter 11, and what have you. That condition remained a troublesome one through the course of Saturday evening and Sunday, and was finally removed only sometime, removed in a way satisfactory to Eastern, only sometime Saturday or Sunday evening. There was some discussion of potential antitrust problems in the Texas Air merger, and specifically the air shuttle markets. And Saturday afternoon we were talking about the possibility, or Texas Air was telling us about the possibility of putting New York Air in a voting trust, or somehow removing them from the Texas Air family as far as direct control is concerned. There was also a discussion of the need that in the event the company pursued a separate course, or in the event that we were able to reach labor agreements with the three unions, that we'd have to have a condition in each of the agreements that the unions would in fact support ratification of the contracts. We had found in the spring of '85 that while we had a contract with the flight attendants, the flight attendant negotiating committee and leadership then went out and urged the members to vote against it. Following the executive committee meeting, there was a telephone conversation between Borman and Lorenzo at approximately 5:30. Discussion was what happens if we have a strike following a merger. Again, the material adverse condition was the subject of discussion. What happens if with respect to DOT approval? Discussion of the antitrust issue. Discussion of the timing as to the approval of the merger. At that point, Texas Air was talking about a 2 or 3 month time frame for approval. We were advising that that's most unlikely, that it's far more likely that we'll go to a 4 or 5 month period. And indeed, I believe I suggested that if we got out for less than the statutory 6 month period, it would amaze me. There was a question that Borman raised as to the problems that the company might experience with labor between the time of an agreement and the time of DOT approval. Lorenzo said that this was a concern that he experienced at TWA as well, that in the TWA deal there was never any hint of disturbances at TWA because of the labor problems, that in his mind TWA's instability stemmed from the icon problem rather than from the labor problem. In the event that there was a strike, he suggested that Texas Air could be very helpful insofar as it could take over aircraft and take aircraft from Eastern or provide people to Eastern. in the event we had some type of labor disturbances. Lorenzo said that he didn't see Chapter 11 as a particular panacea for the company. That it presents many problems. He discussed what you can do with aircraft in a Chapter 11 situation. Lorenzo indicated that he was concerned with people at Easter and he didn't want to have them leaving. And volunteered that if we wanted him to, he'd come over and talk to the board on Sunday. We told him we did not. At 5:50, I had a conversation with Borman, and in which he said that if the Texas Air deal went through, he would leave, and Joe Leonard would run the operation. Around that same time, Jerry Cosley, our head of public relations, came in and mentioned that there were now stories in the New York Times and on the local media about the Texas Air proposal. Schulte, president of ALPA, had already put out a press release. During the course of that evening, we continued to receive reports on the status of the discussions both in Atlanta and in the discussions with labor. About 11 o'clock, we were told by the ALPA negotiators, by our negotiators talking with ALPA, that the ALPA negotiating committee was not moving and that they were being very difficult. At 11:40, there was a meeting with the Colonel and Bill Ussery, in which it was discussed that there would be no extension of time on the sale, and that there is a diminishing likelihood of our being able to reach an agreement because there is no leadership in the unions. That about midnight, we're advised by some of the people on the ALPA side that it's necessary for Eastern to present a proposal that would be acceptable to ALPA. At about midnight, again, there's a conversation between Bill Ussery and Mr. Wimpesinger of the IAM, in which Wimpesinger suggests that the sale of the airline might not be that bad. A little after midnight, we get a report back from the ALPA side, some of the people we've been talking to out of ALPA, Washington, to one of our people that, in their estimation, the ALPA negotiating committee is a totally irrational group, and that at that point it's high risk as to the possibility of there being an agreement. We received a report that, with respect to the flight attendant negotiations, that we are looking forward to some response at 8 o'clock Sunday morning, that our negotiators have a sense that that the TWU people have a sense of urgency, and they view the deadline as a very real one. Again, sometime between 12:30 and 1, there is a discussion among various parties, including the Colonel, Joe Leonard, Jack Johnson, Lou Caden, Bill Ussery, and myself, as to how we move the unions. There seems to be no sense of movement. The movement we've got to make the whole process go faster. And if we don't move very quickly, we're never going to reach agreements by Sunday evening. I think, as I recall, my participation ended about 1 o'clock or 1:30 Saturday night. Sunday morning, we were back for an 8 o'clock telephone executive committee meeting. At that time, We had a report from Atlanta from Howard Turner that in his view we were getting close to a final contract and that he would propose to have a contract in Miami by late afternoon, that the material adverse conditions in the contract were the major stumbling blocks, and that hopefully by the end of the afternoon that would be removed. We also were looking to a fairness opinion from Solomon Brothers, along with the fairness opinion that Merrill Lynch had was going to offer. We had, and the Colonel was not present for the 8 o'clock executive committee meeting. He was meeting with ALPA at that time. During the course of that meeting, it was determined that the board meeting would be put over from 2 o'clock to 6 o'clock on Sunday. When the Colonel returned, he became very angry at that because he felt that the 2 o'clock was a deadline strategy that he wanted us to pursue. We later agreed we'd go ahead with the 2 o'clock meeting. At 9:45, there was a telephone call between Borman and Lorenzo. Borman reported on the executive committee meeting and that there'd be a board meeting at 2 o'clock. Borman told Lorenzo he should not come to Miami. Lorenzo again expressed a concern about his being used as a shill for Eastern's labor problems. Borman assured him that's not the case, but that he had to recognize that he has labor members on the board, and that produces a somewhat unusual situation. Borman expressed a concern the directors needed protection in terms of their personal liability as to the actions they were taking. Lorenzo again said he would back out if he smelled a rat in the process. By late morning, we'd come up with term sheets on the agreement that were pretty much definitive. I've got at approximately 2:20 in the afternoon, the board of directors met, and during that meeting, there was a report on the Texas Air proposal as it then stood. Still at that time, one of the principal issues in dispute between the parties was the material adverse condition, and the company's interest in ensuring that Texas Air couldn't withdraw in the event of a bankruptcy or a strike, and also could not withdraw in the event DOT found some antitrust problem in connection with the merger. It was described that time, the arrangement was described such that Eastern would operate as a subsidiary of Texas Air, and there was a reaffirmation that it's Texas Air's position that the agreement would expire at midnight on Sunday night. Borman then went through a discussion or a summary of the labor situation as it then stood, and specifically addressed the fact that if we in fact were able to obtain labor agreements for the three unions, we also wanted commitments from either the executive board or the leadership of each of the unions that they would in fact endorse ratification of the agreement. The Colonel reinforced the fact that his desire was to see the company continue with reduced labor agreements, and that we not be forced to sell the airline or to go into bankruptcy. Charlie Bryan then spoke and said he was not here to negotiate a new contract, that for 4 or 5 months prior he had made reports to the board and to management on the need to make the company profitable. He had demonstrated, or his membership had demonstrated, their ability to save money with cooperation, that while there had been a period of cooperation in early 1985, that had fallen by the wayside, and that he had seen no substantial efforts on the part of management to reduce costs since that time. He mentioned that he had had a contract that was ratified in May, that was submitted to the membership in October. The second ratification was designed to remove some of the costs that were being incurred in the contract. He felt that the machinists had gone quite far and that it was now up to management to do something. The meeting adjourned fairly quickly. At the meeting, we distributed copies of what was then the current draft of the merger agreement. The outside directors all then met later on in the afternoon at a suite at the Hilton. During that meeting, there were presentations by Dick Spizzirri with respect to the merger agreement, and there was a substantial amount of discussion on potential liability that the board members could incur in the event that the company was sued as a consequence of the transaction. The Colonel went through the labor situation and mentioned the status then of the negotiations with the pilots and the flight attendants, which were on which we still didn't have any surety that we'd have any final agreements, although we continue to believe that the pilots would in the end come along. There was some discussion of individual approaches to Brian to see what could be done to move Brian. There was an interesting side play during that meeting when Jack Fallon, who was the chairman of the executive committee of the board, started calling people on Senator Kennedy's staff and finally did speak to somebody on Senator Kennedy's staff. Senator Kennedy's a personal friend of Mr. Fallon's, trying to encourage the staff person, one of the senior staff people on Kennedy's staff, to call Mr. Wimpesinger, the president of the IAM International, to in turn call Jack Fallon, to suggest to Fallon that the IAM problem might get solved if we permitted the IAM to name a vice chairman to the board of directors. That was a 1.5 or 2 hour exercise that led to nothing. Mr. Fallon basically was proceeding on his own. He wasn't acting with any of the other directors. Mr. Boggs, who represents the pilots on the board, also appeared at one point during that meeting. He expressed a deep concern with the company's ability to reach an agreement with the pilots. He was also concerned about the bankruptcy situation, whether or not the company could weather a bankruptcy, and what would happen if the company were to go on strike prior to the time, if the pilots were to go on strike prior to the time that the company filed a Chapter 11 petition. When the meeting ended, long about 6:30 or 6:45, I would say there was a sense that we might not have labor agreements with all the three parties, but that I don't think anyone knew exactly where the evening would lead. At 7:45, the board came back into session in the auditorium of Building 16. At that time, Howard Turner presented the various terms of the merger agreement. By that time, we were pretty much, Texas Air pretty much agreed to the material adverse condition that we wanted in, although they still had provisions that they could walk away if the company's cash position deteriorated to a certain level within a certain period of time. We were concerned that if the company went on strike, indeed, that the company's cash could fall to the level that would allow Texas Air to walk away. There are a couple of other provisions like that. Those were clearly unacceptable to our board. There was a discussion by Merrill Lynch of the valuation studies. Merrill Lynch was willing to offer a fairness letter, which was very important. That meeting continued on and off until approximately 3 o'clock in the morning. During the course of the night, we received Howard Turner was negotiating over the telephone with the people at Texas Air who were then in Atlanta. Specifically, the conditions I mentioned earlier were still the subject of negotiations. We had structured a situation, some of us had structured a situation in which we had suggested to Solomon Brothers that it might be useful if they did not at that time render a fairness opinion. We had a concern that if there was a way to slow down the process of having the board act on the merger, that might be a mechanism for doing it. We're looking for ways to extend the time to allow labor to come to some agreement with the company. At about 10 o'clock, a little bit earlier than 10 o'clock, the Colonel had a meeting with Charlie Bryan, which I was not present, but at which I'm told the Colonel volunteered to give the machinist the right to name a vice chairman to the board. If only Bryan would go along and make concessions. Bryan apparently was non-responsive to that. I saw the Colonel alone at about 10 o'clock, and at that time, I feel for the first time he expressed a sense that the strategy wasn't going to work and that we were not going to have contracts, that the machinists would not go along, and that we might end up indeed selling the airline, which was an option which I believed he clearly did not want to do. But it was during that relatively brief 5 or 6 minute meeting that I first sensed that he had come to the realization that the Texas Air situation may well have gone beyond where he wanted it to be. At about 11:30, the board came back into session. Solomon Brothers at that time indicated that it could not offer a fairness opinion, that it would take some time to review it. Charlie Bryan stated that he had had an earlier meeting with the chairman of the Finance and Audit Committee, Mr. Barrett and Mr. Crisp. They had spent an hour discussing the IM contract. Charlie indicated that he had already given savings through productivity. He was not going to go along with ALPA and the TWU, that he felt he'd gone as far as he could go. Mr. Crisp asked him whether there was any basis whatsoever to make concessions. Mr. Crisp reported that earlier he had had that discussion with Bryan, that Bryan said he would make concessions only if he got benefits, wage benefits from the cost savings. Crisp, in his presentation, said this was an airline that had 41 years of proud history. They're about to impact 41,000 people, and it's a tragic end to the board and the union's efforts to make the airline work, and it's the end of the line for a very fine organization. There followed a very hectic period when outside the boardroom we had about 40 or 50 employees who were simply standing around waiting to see what happens. During the course of the evening, there were several side conversations with a lawyer from the Skadden Arps law firm in New York who was representing the machinists, and said he represented as well ALPA, but we were never sure of that. There were conversations with him as to what it would take to move the machinists. At one point during the evening, he brought to us a proposal that if we took if we allowed Brian to name a vice chairman to the board, that he felt that would move Brian. None of these side discussions ever led to anything. In my opinion, what was never realized by the fellow from Skadden Arps is that Charlie Bryan was going to make his own decision. I also tend to feel during the course of that night that Bryan's options were almost removed. He was highlighted as his being the key player, and he'd already taken a position saying he wasn't going to make a concession, and I tend to think that evening there was no way he could, and save face, in fact make any concessions. We went back to a problem we'd identified earlier on, that time situation was such that the machinists of the three groups was just not going to be positioned well enough for us to be able to reach any agreement with the machinists. Throughout that evening, I was in conversations with the people who were negotiating with the pilots and the people who were negotiating with the flight attendants. It appeared to me that the pilots, through all the reports I received until about 2:30 in the morning, the pilots were holding out for one thing a little bit better and something else a little bit better. I was told there was a group within the MEC who were filibustering, in effect, against any contract agreement. My impression was that the flight attendants were receiving instructions or assistance from Bob Callahan. Callahan was at the boardroom, but was repeatedly leaving the room to call his negotiators, and from what I could determine, advise his negotiators to hold out for more because the company still had time, but they needed the flight attendants, so therefore he kept urging his negotiators to stand back. At one point, I reported to the board that it was my understanding that both ALPA and the flight attendants had agreed to the basic contours of an agreement. I later discovered that was not correct. I think the key activity occurred at about 2:15 when Bryan and Callahan were both out of the room. There came a point after midnight when the chairman of the executive committee asked all of the inside members of the board, as well as management, to leave. That included Bryan and Callahan, because Bryan and Callahan were treated as insiders for those purposes. It also included Wayne Yeoman and Joe Leonard and all other members of management. Counsel was permitted to stay in the room. Howard Turner and Dick Spizzeri stayed in the room throughout. I was in and out of the room during the course of that period of time. The colonel was ultimately called back into the boardroom for the board to discuss among themselves exactly what to do. At about 2:45, I was in the boardroom along with the colonel and Dr. Yeoman, and Fallon asked Yeoman whether or not there was any way the company could survive if we had 2 out of the 3 contracts. Yeoman said in his mind no, because the company would still experience a loss, as I recall, in the range of $100 to $150 million. The colonel added that in his mind the disruption that would flow from having 2 of the 3 contracts was such that the company effectively couldn't be managed. In my mind, that was the turning point in the evening when the board finally decided there were no other alternatives open to it. I sensed that the board members were struggling very hard to find a reason not to sell the airline. If Yeoman and Borman had at that point said that they thought there was some way the airline could operate with 2 or 3 of the contracts, I have no doubt in my mind the board would have agreed, would have rejected the Texas Air offer and gone ahead with the contract solution. The individual members of the board, both Bassett and Crisp, and at another point Tom Boggs, had met with Bryan. I think they had felt Bryan was not going to move. My impression was that our contacts with the International, through Ussery talking to Wimpesinger, were such that the International was not going to do anything for us. At about 2:30 or 2:35, there was a discussion of the action that the board would take. The chairman of the executive committee called for a vote. Colonel Borman said he would not stay in the room for a vote, that there were certain things he could not tolerate. I should go back. There was an exchange a little bit earlier between Bryan and Borman on the actions that the board would take. Charlie Bryan took the view that the board is making its own decisions. It's not Charlie Bryan who's doing anything. Borman turns to him and says, the board, everyone's going to pin it right on you that we sold the airline. The colonel said that the company could not operate without an IAM agreement. Bryan recited his version of the history as to what he'd done on his two agreements. Tom Boggs asked Bryan whether or not there were any negotiations going on between the International IAM and Lorenzo. Charlie said no, there were not. Dr. Posvar, one of the members of the board, said that he felt this was a historic crossroads in the relations between labor and management in America, that we had attempted an experiment, that it had failed, and was going to be significant harm to the labor movement. The colonel said we'd had something good going here, and rather than throw stones, we need to try to operate on some basis of cooperation. Bryan said that management had failed to exercise or behave in any manner that would demonstrate its trust. Between the company and the union, there was a very nasty exchange between the colonel and Charlie, in which the colonel said that you shouldn't listen to this man. He hears footsteps in one ear and raindrops in the other, or some such phrase. It's one of the few times when the colonel became so frustrated he resorted to a personal attack on Bryan. Going back to about 2:40 when the vote was taken, the colonel excused himself. The vote was taken. There is this extraordinary situation that the merger agreement called for, certificate of cooperation with the company calls for a 2/3 vote. We went around the room counting once, and then we couldn't figure out what 2/3 of 21 was. So we did the vote a second time. We had what I thought was this unusual situation of this historic moment in the company's history, and nobody knows how to count the votes. We finally determined that indeed there was a sufficient number of votes and that the sale had been consummated. Colonel came back. By that time, the colonel was standing in the back of the room. He came back down and asked if there was any other business. We said we would go up and call Texas Air to inform them of the action that had been taken. As we were waiting, I knew that there was a press release that we had prepared as to the against the possibility of a Texas Air sale. I went out and got the press release and read it to the board. Bryan said something at the end saying, "You can't pin it on me." And I responded to Bryan along the lines that we know exactly who betrayed us, and it was you. Joe Leonard at that point was in the room too. Joe was as emotional as I and made some comment to Bob Callahan that he really demonstrated his leadership by not reaching an agreement and letting the airline be sold. I then walked outside with the colonel, and he said to the group that was assembled outside that the board had exercised its best judgment and had sold the airline, and then with a somewhat quiver in his voice said he couldn't say anything more, and went to the elevators and went upstairs. Howard came back and said Texas Air had accepted our offer and that we'd proceed to the drafting of the agreement. The meeting was at that point then adjourned. Curious point, at that point in time, I'd been on the phone just before the board acted, or just after the board acted. I'd been on the phone with the negotiators, where our negotiators were negotiating with TW and our negotiators were negotiating with ALPA. I called each of them and said, the airline has been sold, we should break off all negotiations. Our negotiators then left. A few minutes later, when we were upstairs in Borman's office, we reported what had been done, and with some degree of anger, he said that we should go back to ALPA and tell them they better sign the agreement then. I then left, but I understand we then went back to ALPA, and ALPA then signed an agreement. We never had an agreement that evening with the flight attendants. The next day, the colonel received a call indicating that Pan American was interested in talking to us about a merger if there was still a possibility. He rejected that out of hand, and in my presence called Frank Lorenzo and told him that he had no intent of going back on his deal, and he really didn't care who was offering what. He then instructed us to ensure that the merger agreement be signed that day, which we proceeded to do. One point during the board meeting on the evening of the 23rd, Mr. Crisp or Mr. Bassett, and I forget which one, reported that Brian had volunteered to accept or give a 15% concession, provided the colonel resigned as chairman and the board sought out a new chairman and chief operating officer. There was a brief discussion before the board on that subject, and it was rejected out of hand. The logic that the board members brought to bear was that they could not permit the IAM to choose the chairman of the company and run the company, which had been the essential impact of that proposal. And that had been something that had been discussed a dozen times, or been proposed to us a dozen times earlier by the IAM. Not the 15%, but you get rid of Borman and we'll do something for you, and repeatedly Brian had been told, and other representatives of the IAM had been told, that that was not something the board would agree to do. The Sunday night proposal, I think the board also took to be somewhat, I don't know if sleazy is the right word, but it was Charlie coming in and saying, everybody else gives 20%, and I'll only give 15%. And that, too, I think the board viewed as being completely unacceptable, because you then have the company accepting 15% from the IM and asking 20% from other groups, and that was simply not something that the board would agree to do, nor was it something the management would recommend to the board that they do.
Is it too simple to say that there was this personality conflict that was at the core of the problem?
I think there were institutional problems, and I think there was an aspect of personality conflict. I think Charlie Bryan dislikes the colonel intensely. I think he's jealous of him. I think Bryan has, over time, come to have an inflated view of himself and his role as a labor leader, and I think he genuinely believed that he was in a position to oust management. I think to some degree, he felt he was playing his cards to the ultimate, that in the end management would, or the board would, give in to what he was looking to do, and that he would effectively be running the company. I think over time, one of the problems we've experienced is that I believe Bryan has come to totally accept the idea of co-determination, that somehow he has a right to play a significant role in the management of the company. I don't think Bryan understands any longer his role as a union leader, or certainly he doesn't understand his role as a member of the board of directors. He has done everything one can possibly do wrong when you're a labor member sitting on the board. We had originally looked, and I had provided him with articles, speeches, stories about Doug Frazier's service on the board of Chrysler as being somewhat of a guide. Brian followed no example. Brian, in his own mind, represented, and as far as I could see, he always believed he represented the employees on the board. He never could understand that there's a difference between being a board member when you represent the body of the stockholders and being a union leader when you have a specific special interest group. I think that institutionally presented a problem for him the night of the merger. I think, yes, I think there was a personality conflict between he and Borman. Was that the controlling feature? I'd say no. It was one of many different factors that went into play. I think the overwhelming factor was that Brian believed he was going to win. And I also believe that the other side of that is that the company thought that it was going to succeed in getting 3 labor agreements. I am convinced that Colonel never came to believe that that would not happen until the evening, until late on Sunday evening. And perhaps we'd all talked ourselves into the fact that Brian in the end would go along, ignoring consistently that Brian too saw he had a very large club. Even with that, I would say, had it been positioned, perhaps, it's Monday morning quarterbacking, had it been positioned somewhat different, had we had, if we'd been able to follow our original plan, where we had the Texas Air offer considered on a Friday, and the board not meet until Tuesday, that extra time might have given us the opportunity to come to some accommodation with Brian. So I think the company would have, in the end, if Charlie had given us 20% and the minimal changes we were asking for in health and vacation benefits, I think we would have agreed to certain changes. I think we would have added a vice chairman to satisfy him. We would have done some of the committee things he was suggesting at one point. But he had to come along with 20% and some vacation changes and some health changes, and he wouldn't do it. I think all along he understood that the company was willing to go a fair distance. If he would go somewhere, he would give us something, and in the end, in my mind, he simply thought he didn't have to. And on that Sunday night, I do believe he felt himself in such a corner and had been positioned in such a way that he probably couldn't, and save face and do anything.
Has there been any evidence since then that he's had second thoughts about that? About his role and how constructive?
The only second thoughts I can see that he may be having is his constant reference in letters as recently as one I received from him today that says, had we only cooperated and had the board agreed to sell the company to the employees, this would never have happened. I think it weighs heavily on his mind because I think he's suddenly come to realize, or he came to realize over time in the last 8 or 9 weeks, that he lost his greatest strength. His greatest strength was the company's need for him. Now suddenly the company doesn't need him, and he's sitting out there as a weakened union leader.
Was Callahan's role any more constructive?
No, Callahan has absolutely no constructive role. Callahan plays virtually no role on the board. Callahan is viewed as a very weak, inept individual who sits on the board and occupies a seat, and that's about all.
And the other 2 members that represent Alpha and the non-contract, they both have more practical experience as board members elsewhere, don't they? I can't have Boggs and
Taylor. They have.
They play that role.
They sit on some other boards, I believe.
Yeah. But they don't. They're not as linked as tightly to the Alpha as if they were officers in Alpha.
That's correct.
So they can play a somewhat more typical role.
Yes.
Has that having union officials on the board, has that caused the board to function differently? That is to say, are more things done off the record, not on the record? Or
No, the board always acts the board must act when everyone is present. I don't know if it's prompted more discussions on an informal basis among some members of the board. That may well be the case. One of the problems we found is that when Brian and Callahan first came on the board, the company tried to be as open and candid on its situation, on the various financial problems it was having, its traffic and what have you. We were as open as if they were not there. What we found is that the information we were giving them as board members was finding its way into the media or into union documents in a way to do injury to the company. It became evident that to us, or to me at least, that Charlie viewed the board as an opportunity to get information which he then uses to oust management. So I think the problem was his inability to really understand the distinctions, the very difficult situation he had in sitting on the board as a member of the board and as chairman of one of the company's principal unions.
I take it you still believe that that role is, it's possible to play that role.
I think
the Chrysler example.
I think with very sophisticated union leaders who are willing to, who understand and are willing to undertake the burden of a dual role, I think it's very possible, and it probably can be very constructive, but it takes a kind of union leader that doesn't exist at Eastern. I think we moved too quickly with the wrong people.
I've kept you longer than you promised to give me, so let's call a halt here.
Fine.
Thank you.
Okay.
Appreciate your time.
Sure.